Retaliation doesn't always show up in one big moment. Too often, it's about a pattern. You start to notice small changes at work, opportunities that used to come your way. They stop coming. Someone makes a comment that stings you a little, or suddenly you feel like you're being watched closer than others. Most people don't realize it right away, but these moments can be the first sign that your rights are being violated. Today, we're talking about a Supreme Court case that reshaped how we think about discrimination, especially in federal workplaces, and what it can teach every employee about recognizing when you have engaged in a protected activity, even when it doesn't seem obvious. So by the end of this video, you will understand why even small traces of a bias can violate the law, how to recognize when you might have already engaged in a protected activity so you can protect yourself before things escalate. Hi, I'm Harlow Reed. For informational purposes only and is not a substitute for professional legal advice. Always consult with a qualified attorney or HR professional for specific guidance tailored to your needs. And hey, don't forget to like and subscribe. Noris Babb was born in 1960 and worked as a clinical pharmacist at the Department of Veteran Affairs Medical Center in Bay Pines, Florida. The Bay Pines VA healthcare system is one of Florida's largest VA medical networks, serving more than 100,000 veterans annually across 10 counties on the state's Gulf Coast. It's a major regional center that includes outpatient clinics, long-term care, mental health, and pharmacy services, making it a significant workplace for federal health care workers like Babb. She'd worked hard, built seniority, and earned an advanced scope designation that made her eligible for promotion from the GS-12 to GS-13 level on the federal pay scale. And that was a big step for her career, but in 2013, that designation was taken away. And around the same time, she was denied training opportunities and passed over for positions in the anticoagulation clinic. Then in 2014, she was moved to a new position, one that was still at the GS-13 level, but her holiday pay was reduced. So to her, it felt like she was being pushed out of opportunities that she'd earned. But it wasn't just the changes to her job. Babb said that some of her supervisors made age-related comments. One supervisor joked that the movie Magic Mike was a middle-aged woman movie. Another reportedly called her a Mau Mau, which she understood as a grandma comment. Those comments might seem harmless on their own, but when you're being denied promotions and training, at the same time, they start to form a pattern that suggests age bias might be playing a role. Norris didn't stay silent. She filed an internal EEO complaint, a protected activity under federal law, saying she believed age and sex discrimination and retaliation were factors in how she was being treated. Like many federal employees, she had to go through the administrative EEO process first. That means she reported her concerns internally, cooperated with investigations, and waited. But after months passed, she still didn't feel her claims were being addressed. And eventually, she exercised her right to take the next step. She filed a lawsuit in federal court against the Secretary of Veterans Affairs. In that case, she claimed she had been discriminated against because of her age and gender, and that she had faced retaliation for engaging in protected activities, including filing her EEO complaint and supporting other employees who had done the same. The Veterans Administration responded by saying it had legitimate non-discriminatory reasons for all the employment decisions that Babb challenged. Things like operational needs, scheduling changes, and qualifications. The district court agreed with the Veterans Administration. The judge found that although Babb had established a prima facie case, meaning there was enough evidence to raise suspicion and to move the case forward, the Veterans Administration had provided valid explanations. And she hadn't proven that age was the but-for cause of those actions, of the adverse employment actions that she experienced. In other words, she couldn't show that age was the the one and only reason behind how she was treated. But Norris didn't give up. She appealed that decision to the 11th Circuit Court of Appeals. And there, she argued something incredibly important. And this is what ultimately reached the Supreme Court. Under the federal sector rule of the Age Discrimination in Employment Act, Babb argued age doesn't have to be the only reason for a personnel decision. If age played any part at all, even a subtle one, the law was violated. So let's stop for just a brief moment and talk about the relevant aspects of the Age Discrimination in Employment Act that you need to be aware of. The ADEA has two main parts. The first is the private sector provision. That's the one that covers private employers, state and local governments, employment agencies, and labor organizations. And under that section, an employee has to show that age was the but-for cause of the adverse action they experienced, meaning the decision wouldn't have happened but for the employee's age. The second part is the federal sector provision, which applies only to federal government agencies. That's the one at issue in the case we're talking about today. Now, technically speaking, Babb v. Wilkie doesn't change the rule for private employers. It clarifies the law only for federal employees. But I wanted to cover this case anyway because even for private employers, it demonstrates something powerful. That bias doesn't have to be blatant to be real. That small, cumulative decisions like denying training, changing pay structures, or making age-related jokes can reveal how discrimination seeps into the decision-making process. This is why you hear me say it all the time. Document everything. Documentation is one of the most powerful tools you have. So don't underestimate the value of writing things down. It's how you show that something isn't just a one-time incident, it's a pattern. And when you can demonstrate a consistent pattern of inappropriate conduct, you're in a much stronger position to prove that discrimination or retaliation has taken place. The principles from this case remind all of us that workplace decisions should be made free from any form of bias, age-related or otherwise. Federal government may have the stricter standard, but the lesson applies everywhere. Now, if you want to see how this plays out outside of the federal workplace, I actually covered another case about a school principal who fought against a demotion after believing she was discriminated against due to age. That video's called Workplace Investigations Gone Wrong. What happens when employers mess up? It's a great example of how age bias and poor investigation practices, it can show up in regular workplaces, schools, or any organization, not just in the federal government. I'll link that video in the description if you want to learn more. Okay, so back to the case. The case went all the way to the U.S. Supreme Court, and in 2020, the Supreme Court agreed with Noris Babb. The justices said that ADEA's federal sector provision requires that all personnel actions shall be made free from any discrimination based on age. The key phrase there is free from any. That means personnel decisions must be completely untainted by age. Even if age wasn't the main reason, even if the employer had other valid reasons, once age enters the decision-making process, the law is violated. However, to get money damages or reinstatement, the employee still has to show that age was the deciding factor in the outcome. But the key takeaway is clear. For federal employers, there's zero tolerance for bias in the decision process itself. This case matters far beyond federal workers. It teaches a bigger lesson. Discrimination and retaliation often show up in small decisions that add up. Remember what Noris Babb said. She recalled comments that made her feel like she was being viewed differently. So it's not always about losing your job. Sometimes it's about being left out of meetings, denied training, or treated differently after you've spoken up. And speaking up isn't limited to filing complaints. It can be as simple as calling out something that violates company policy, asking a question about a process that doesn't seem fair, or correcting misinformation about your work. Those actions, standing up, asking questions, challenging a narrative, they can all count as protected activities. So here's the hard part. Most people don't realize they've engaged in a protected activity until something happens afterward. That's why I created the Retaliation Shield, the activity checklist and workbook. It will walk you through what counts as protected activity, and some of it might surprise you. It's written in plain English so you can recognize the early warning signs and understand when your rights are being violated. Because you can't protect yourself from retaliation if you don't know already taken a protected step. Bias doesn't have to be blatant. Doesn't have to be blatant to be real. Every worker deserves to have their career made free from discrimination and retaliation of any kind. Knowledge, that's your shield. If you want to understand whether your actions might be protected, or if you're wondering whether what happened to you was a violation, grab a copy of the Retaliation Shield, the Protected Activity Checklist and Workbook in the link below. And remember, awareness is power. The sooner you recognize when something isn't right, the sooner you can take back control of your story of violation. I'm Harlow Reed, and this is the HR Insider. Thanks so much for watching today.